Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Practice Group, and it's a place for thoughtful conversations on environmental and natural resources law and policy, ranging from the latest developments to perennial topics like litigation, enforcement, and compliance assurance. We're glad you're spending some time with us today. All right, the temperatures are cooling down just a little bit here in Texas, and that means football, that means fly fishing and hunting for some of you. And for people like me, that means that the Supreme Court is also back in session. We've got a lot of new developments at the Supreme Court. Obviously, this summer was full of all kinds of news about the Supreme Court, and we have a new justice on the bench, Justice Jackson. And environmental issues are front of mind at the Supreme Court and indeed leading off at the Supreme Court. Last term, we saw a really significant case, West Virginia versus EPA. It was the opinion came out in June, and that inspired at least probably 1,000 news articles and opinion pieces on the Supreme Court's stance on statutory interpretation, on climate change and the future of climate regulation. And this term, which began just last Monday, led off with Sackett versus EPA, a case that is going to be really significant for determining the jurisdiction, the geographic application of the Clean Water Act moving forward. So I want to bring on a couple of my colleagues, Sara Burgin here in Austin and Navaro in DC. And I have spent a lot of my time at the law firm talking about the Clean Water Act and waters of the United States with these two fine people. So welcome back, Anne, and welcome, Sara. I think this is your first time on the podcast. How does it feel?
It feels wonderful. Lovely to be here.
And I'm excited to be back. This is always
Excellent.
a good time to have a fun conversation with my colleagues.
And so this case, Sackett versus EPA, is actually, in my mind, I've been thinking about it as Sackett 2, because you've really got to hand it to Michael and Chantel Sackett. These are a couple of landowners who have been fighting the Environmental Protection Agency over the development of their, small acre, about 2/3 acre lot that is near Priest Lake. And they have been fighting EPA for 15 years over EPA's order issued, I guess, back in 2007 for them to stop filling a wetland on their property. And the Sacketts have gone to now the Supreme Court 2 times over this enforcement action. I think it's rare to get to the Supreme Court at all. I think there's, I've heard that there's anywhere between like 5,000 to 10,000 petitions for a writ of certiorari, and the Supreme Court in any given year will pick maybe between 70 and 80 petitions. And so I think it's actually probably harder to get into the Supreme Court than like an Ivy League school or something. So it's quite an achievement that the Sacketts are there for the second time. In the first Sackett case, the Sacketts were seeking review of that initial compliance order once EPA had learned that the Sacketts had filled some of the wetlands on their property. They sent basically the EPA's version of a cease and desist order, alerting the Sacketts that they could be subject to penalties. The Sacketts sued EPA saying, well, we want judicial review of this compliance order. EPA said, no, that's not final agency action yet. We haven't actually sought to collect a penalty from you. And that made its way through the court. That made its way to the Ninth Circuit and the Supreme Court. And actually, I should know that answer. I think 2014 said, you look like you disagree.
No, I'm not sure. I'm not good at keeping dates in my head. So I
always get it confused
with
Hawks. Let's just say that on their first visit to the Supreme Court said that, yes, you can review these types of compliance orders. Yes, they do determine legal rights and obligations. Most importantly, it starts the clock running for your daily penalties under the Clean Water Act. So, Sara, I want to start off with you and welcome you again to the
Daniel,
pod. Go ahead.
I hate to interrupt, but we were told we're allowed to interrupt, so I'm just going to take advantage of that. You are allowed to interrupt.
That's the joy of podcasting.
Because you made the mistake of mentioning hawks. So I thought I would just offer kind of a predicate comment building on Sackett 1, where, of course, as you said, the court found that an enforcement order was final agency action that could be challenged. And then in the Hawks case, the Supreme Court found that a core jurisdictional determination as to whether you have wetlands on your property was a final agency action that could be challenged. And there had been a circuit split on that and litigation over that question for years. And I think both of those cases, certainly reflect some of the justices' concerns that we'll talk about that we heard in the Sackett 2 argument, which is, do individuals have to go through years of process and spend thousands of dollars to kind of know what the situation is on their property, and is that fair? And some of the justices, I think, are quite concerned about that. And I think Hawks and Sackett 1 show the court kind of being very aware of that, look, these agencies take actions that have real impacts on people. And maybe judicial review comes at an earlier point than the government had previously said.
Yeah, the Supreme Court has definitely been uncomfortable with the fragmented Rapanos decision, which we'll talk a little bit about throughout this podcast. And you saw the concurrences and the dissents in those decisions in Hawks and in Sackett saying, we've got to do something to clean up the waters of the United States, phrase in our cases on it. So Sara, talk to us about why the Sacketts are at the Supreme Court this time.
I'm happy to do that, but I have to completely get off point and wonder where these people are living while this 15-year process is ongoing. I mean, is this their retirement home and they have 15 years before they need it? Or have they built their home? It's like 15 years is a long time to not be able to build whatever it was that you were going to build.
Do you think maybe it's an Airstream or a tent?
Well, I
would
think
get old
I have,
after 15 years.
I think I have read that I don't actually know what the situation is. I vaguely recall reading that they have a rental property where they rent in the area, but I'm not sure of that.
Yeah, that would be sort of depressing. Okay.
I was also thinking last night about the official at EPA who drafted up what he thought was just going to be an ordinary compliance notice in 2007, dashed it off to the Sacketts. Yeah. I wonder if he ever thinks about that, or she. But so what, why are they here at the Supreme Court now? What's their argument?
So now they are back following August 2021 decision by the Ninth Circuit, this time on the substantive issue of whether the wetland on their property is subject to jurisdiction under Section 404 of the Clean Water Act. So they're finally getting around to the actual jurisdictional substantive issue. The district court held that the wetland is subject to jurisdiction and that they should begin removing the fill that they've already placed on the property. The Ninth Circuit upheld that decision, the district court's decision. So before the Ninth Circuit, the Sacketts argued that the Scalia plurality in Rapanos provides the governing legal standard. Because the wetland on their property does not have a continuous surface connection to waters of the U.S., the wetland on their property isn't jurisdictional. The Ninth Circuit held that the wetland is jurisdictional because the correct governing legal standard is Justice Kennedy's significant nexus test. And they agreed with EPA's conclusion that the significant nexus exists for the wetland. Just to add context for consideration of the arguments that we're going to discuss in a few minutes, because I think it's interesting, the Ninth Circuit included EPA's conclusion in the decision, and that is that the wetlands on Sackett's property were adjacent to a jurisdictional tributary, and that together with similarly situated wetlands complex in the area, that there was significant nexus to Priest Lake, which is a traditional navigable water. So the Ninth Circuit's decision is based on significant nexus, and that is what's before the Supreme Court.
My powers of prediction, I think, are already questionable, but especially with this case, one of the lingering issues after the last Supreme Court case, Rapanos versus the United States, which was the last time they took a crack at trying to figure out what waters of the United States means. We had a four-person plurality or four-justice plurality saying, hey, we need a continuous surface connection between a traditionally navigable waterway and another water feature for that water feature to be a WOTUS. And then we had Justice Kennedy's one justice concurrence saying, well, we need to use a significant nexus test. And I guess in the past, let me do the quick math here. What is that? 13? Yeah, 13 years since Rapanos. Courts everywhere have been struggling with like how much of Rapanos is that surface connection, how much of it's the significant nexus. And the Ninth Circuit said, well, we just look at significant nexus, like you said, Sara. So that's a different approach towards dealing with a fractured opinion than most other courts have taken in generally. So I was curious if the Supreme Court was just going to come back and say, no, you need to read Rapanos this way. And that's definitely not what happened. They're here to try to fix the problem. They want to talk about what counts as a WOTUS, what could qualify as a WOTUS, how wetlands come under jurisdiction of the Clean Water Act. And so I was wrong on that. So we'll see what other predictions I make on this podcast and how I fare. But they're definitely going to try to fix WOTUS if they can.
Yeah, I mean, maybe. I suppose I could take some various different positions and we can argue about them in this podcast without having to commit myself to anything in particular. But it certainly was very interesting the way the argument played out, because for the first at least half, I kind of wondered if one of them was going to decide they'd improvidently granted cert, because they spent the whole time talking about adjacency, which is the predicate question that's teed up in the case. So significant nexus comes into play with wetlands when they are adjacent to a water that is not itself a traditional navigable water. So
tributaries, ditches.
Tributaries or ditches. So these wetlands, the agency found, were adjacent to a non-navigable tributary to Priest Lake, the navigable water. So the question that the Sacketts have really pushed and that the court spent a good deal of the argument talking about was the origin of adjacency, where that came from, why it's broad enough to encompass a wetland that is cut off by a natural or man-made feature like a berm or a road, and whether it is broad enough and how a landowner was supposed to know how close the wetland had to be in order to be considered adjacent. So after that discussion, I kind of wondered, well, what are we doing here? Because a lot of the justices seemed to feel pretty strongly that adjacency was well established in the law. Of course, significant nexus comes into play. Once you agree that the wetlands are adjacent, then the question is, do they then have a significant nexus to a TNW sufficient to bring them within the scope of the Clean Water Act?
Well, but if you did what they're asking and you just use the Scalia opinion, does significant nexus come in?
No, right. So they're saying you don't need any of that. It's adjacency is wrong, or if adjacent is okay, it really means touching, and there has to be a continuous surface connection. So the Sacketts are advocating for a position that I didn't hear the majority of justices being very warm about.
No, I agree with you. I mean, to me, it seemed like that the Sacketts are arguing Scalia's opinion and then Riverside Bayview for the definition of adjacent, and then that's it. I mean, it seemed to me that it could be fairly, well, narrow from the standpoint of what they're a clear-cut, bright line. But like you say, it would leave a lot of question about what you're going to do with a wetland that's adjacent to a tributary. Are you just going to use the same test? Would you use the Riverside Bayview test there instead of the significant nexus approach?
You know, and then the government and the Sacketts disagree on what the Riverside Bayview test is. I mean, it's the government's position that the court misinterpreted Riverside Bayview and Rapanos, and that the Supreme Court in Riverside Bayview was talking, never kind of considered the question of the outer limit of wetlands. And do they have to be continually touching another body of water? The government's view is that, Riverside Bayview was really looking at what types of bodies of water might be regulated under the Clean Water Act. But it's the Sackett's view that you have to be able to, like this summer, I was in Northern Ontario. I wanted to see something that was up the shore from where we were in a lake, but it was really marshy. So I anchored my boat in about a foot of water. I got out of the boat in the lake, started to walk through the water. Then I got to where there was some grasses. I kept walking through the grasses. Then it got a little muddy. Then there got to be some more vegetation. So the Sackett's view is that's the only kind of wetland that can be jurisdictional.
That's
if you
right.
can just keep walking and keep your feet wet. But, as soon as there's a natural berm, even if there's wetlands on the other side, those aren't jurisdictional. And I just didn't hear the court having a lot of sympathy for that view, except for maybe Justice Thomas and Gorsuch and maybe Justice Alito.
That's right. Justice Kavanaugh seemed to have some real issues with the Sackett's preferred understanding of adjacency, which is, like you say, Anne, the way they presented it is that, you basically have to have a wetland that's not just in the vicinity of a traditionally navigable waterway, but it's got to be touching it. And it's got to be touching it in such a way that it becomes really difficult to draw the line where
right.
the T&W begins and ends. So there's a lot of skepticism, I thought, over that point from some of the justices that are sort of sometimes grouped with the right-wing side of the Supreme Court, but who have considerable bench experience and concerns about the fact that the agencies have regulated those types of wetlands for about 45 years now.
Yeah.
And other types of wetlands that are connected by tributaries and other features.
I was out in Santa Fe this past weekend and looking at exactly the different part of the world from what Anne was talking about, seeing, just all of the arroyos out there that have absolutely no water in them at all most of the time, except right after a rain, which we happened to actually be there while it was raining. And so it's interesting to look at that world because they have a very different view of all of these issues.
Well, they definitely do.
And one of the things that the Sacketts raised in their argument, and this I think was picked up by some of the justices in questioning the government's position, is that it's one thing to have a phrase like waters of the United States that's going to require an agency to come in and through rulemaking and guidance say, well, this is what we think that phrase means. This is what we think adjacency means. And it's another thing when there can be extensive criminal penalties faced by anyone who gets that wrong, right? Who makes a mistake, who makes we say that ignorance of the law is no excuse, but that takes on a little bit of a different tone when you're talking about a lot of agency decisions and guidance informing that agency, when you have to hire a consultant to come out and give an opinion and so forth. What did you guys think of some of those arguments?
I mean, I think those arguments are very persuasive. And, I think that would potentially be one of the benefits of what the court could do with this decision. But as Anne mentions, it's very difficult to come up with any kind of bright line test. I mean, that's what they're hoping for, but it's tough. That's why it's been going on for so long.
Yeah, I mean, I think those concerns are, for where an environmental statute reaches so far into the lives of everyday people and doesn't just affect the operation of the plant down the road or, something like that. Certainly, the concerns are very meaningful. And I think the government was very respectful of that in the argument. And it's probably not much solace, but I think what the government said in the argument is probably the case, which is in terms of criminal penalties, it would be highly unusual for the government to go that far unless somebody kind of really doesn't want to work with the government and is kind of a repeated flagrant violator. Again, there are going to be plenty of people out there who say the act reaches too far, people are within their rights to do these things. But I think the government's response was kind of, look, as long as you play by the rules and are reasonable about it, you're not gonna, we're not gonna throw you in jail just because you legit didn't know what you had on your property and made a mistake. You've got to be then uncooperative and perhaps a repeat offender to really be in the crosshairs.
I can hear Justice Gorsuch's questions in my head, though, saying, that argument sometimes boils down to the government saying, well, trust us, we won't abuse our authority.
Yeah.
Right.
And in this case in this case where they've said, go in there and dig all of that gravel out that you've placed in there, that's not cheap.
Yeah. I mean, again, maybe this is all something for Congress to address. And we know how difficult, if not impossible, that it is for them. But, they have enacted a fairly broad test. And, there were a number of justices who pressed both parties for kind of a new rule. And all they got was the continuous surface water connection rule from the Sacketts, which most of them didn't seem to find appealing. I'm personally kind of hopeful that, I'm not sure where another new rule would come from at this point. I thought it was interesting they pressed the government as to, where did significant nexus come from when you get to that stage of the analysis? And the government said, well, you all created that. But I don't know where they would pull something else from. So to me, it's kind of hard to see where they go if it's not basically affirming the status quo or going with the Sackett's interpretation. I'm not sure that anybody identified a middle ground for them. Sara, did you hear a middle ground identified?
Well, as I was reading it, I kept wondering if the attorney for the Sacketts, instead of him just saying over and over again that, no, it can't, it has to be continuous service connection. You can't have a berm. You'd be out if there's a berm. If there's the road, we're out. But there is, at least in this situation, there's not only a road, but there's land and a housing, at least some houses between this lot, this residential lot and the Priest Lake, which is apparently where the government is saying that it's adjacent to. So, maybe there's room there. I mean, maybe if the attorney had said, yes, there's a berm, if there's a road, if there's something, yes, it could still be, but there's a land, there's, a stretch of upland between this and the lake.
I almost think the most telling thing and maybe the most problematic thing that the Sackett's attorney said in the argument for their position was that he recognizes that there are cases that would be gray areas. Well, then we're back to an agency coming up with some sort of reasonable interpretation via a regulation, as opposed to the type of bright line rule that they wanted to advance and have the Supreme Court adopt.
So we've talked a lot about what the Sacketts are arguing, and what's the government's position other than, well, the Sacketts obviously violated the Clean Water Act and filled their property with gravel. What arguments did the EPA advance before the court trying to bolster their position and really retain jurisdiction over these features? Because that's what this case is about.
Well, I think it was kind of twofold, and we've talked a little bit about it. The first question was the definition of adjacency, right? And is that definition in its currently codified form, which includes wetlands that are separated by a physical feature like a bank or a berm, is that reasonable under the Clean Water Act? And obviously the government's position there is, look, that's been the definition for decades, ever since the Corps got roundly chided for trying a much narrower definition. And not only has it been the definition for decades, but it furthers the purpose of the act. And I know some folks don't think the purpose of the act should have much role in statutory interpretation, but furthers the purpose of the act by affording protections to waters that themselves protect and enhance traditional navigable waters. And then there's Section 404G of the Act, and there was a lot of discussion on that. A number of justices...
Just tons of it.
A number of justices seem to think that creates real problems for the Sacketts and their position on adjacency. So, 404G is the one that allows the states to assume the 404 permitting program. But in relevant part, it reserves part of the authority to the Corps of Engineers to the extent traditional navigable waters are involved. And as part of that reservation of authority, the Corps still keeps traditional navigable waters permitting, as well as permitting over adjacent wetlands that are adjacent to traditional navigable waters themselves. And so, the argument is, look, when Congress put that in there, they knew and were well aware that adjacency was defined as neighboring, but also potentially separated by some upland physical feature, and that term has been used in practice for decades.
And that even if it wasn't clarified through decades of use that it would still appropriately be within the EPA's and the Corps' authority to clarify what adjacency means. I thought there were some particularly persuasive questions from Justice Jackson, and this was her first oral argument, asking about, well, isn't it within the agency's authority to tell us what adjacency means? Why do we need to jump to this conclusion that the Sacketts are arguing that adjacency necessarily means abutting, directly touching? Why can't it mean in the vicinity of? So I thought those were good questions, but back to you, Ann.
Yeah, they were. And I think it was I can't remember if it was the Chief Justice or Justice Kavanaugh, who even said, look, what about railroad tracks coming into a train station? Those aren't physically touching the building of the train station itself, but they're still adjacent to the station. And that's kind of the common dictionary definition, that it's kind of more neighboring as opposed to actual touching. The government also spent some time on Riverside Bayview, I thought fairly persuasively, because the Sacketts have emphasized that the wetland at issue in Riverside Bayview was more abutting and touching the traditional navigable water. And the government, I thought, persuasively explained that Riverside Bayview doesn't really deal with the precise question that the court's dealing with today, and so therefore was not persuasive the other way. And then, in the discussion on significant nexus, I think, maybe as a practical matter, the government's arguing it is a logical way to place a limit on jurisdiction. Not all wetlands adjacent to non-navigable tributaries are going to be jurisdictional, because some of them are just too minor to have any meaningful impact on a downstream traditional navigable water. So I think as a practical matter, the argument was trying to make that an appealing limit on federal jurisdiction, emphasizing that the government isn't taking the position, according to the government, that its jurisdiction is boundless.
Sarah, any thoughts on that?
Well, I have a question I wanted to ask Sara too, though, and I don't.
Oh, sure.
So I'm just, I thought I guess we can't expect Supreme Court justices to be absolute experts on everything. I mean, that kind of makes sense, right? They get such a diversity of cases, and yet we do expect it. So I was a little struck by what I perceived as maybe some confusion or misspeaking on some of the issues. And I thought the discussion around County of Maui, I was kind of confused about how they thought County of Maui relates to what's in front of them now. Sara, did you have thoughts on that?
No, I had exactly the same reaction that you did. I think it was Justice Jackson was talking about sort of this underground flow that was she was distinguishing it from groundwater, I think. And that the potential for this underground flow could perhaps be a basis for jurisdiction, which, yeah, I thought that was a misapplication of Maui.
And I thought, and then I thought Justice Barrett and Justice Gorsuch kind of piled on a little bit.
They may have, yeah.
Wanting to know, how many parts per million have to flow into the TNW to have it be connected. And I just wasn't sure where all that was going.
Yeah, and I think that was Justice Roberts maybe that was trying to understand the significant nexus test or something. But yeah, that was odd too.
The best way that as I understood their references to it, it was almost more like they were just using the facts from County of Maui than anything else, and trying to say that you could have some subsurface flow that wasn't just ordinary groundwater migration, and that maybe you need to be protective of that could cross under a road, that could cross under a berm, potentially. And I think there was also a reference, I can't remember the justice that made it, but basically, instead of having a bright line rule, County of Maui set up that, 8 or 9 factor test for whatever the functional equivalent of a discharge was. And they're like, well, maybe you do something like that here. Maybe you have a lot of different things you look at, and you just have to be comfortable with hiring a consultant or doing a lot of extra work to figure out whether you're regulated or not.
But I mean, that's sort of what we've already got, I think, with all of the core guidance and such. Mm-hmm. So it's not in the case, but yeah, it's in the guidance. I wanted to bring up, and I wanted to kind of get Ann's thoughts on, I think it was Justice Alito sort of in the very end of the argument raised the issue of this parenthetical phrase and its potential for significance, and whether he was trying to bring in the major question doctrine. Did you interpret any of his questions that way?
I'm not sure I was focused on that part of it, Sarah. I don't really see this as a major question case. Do you?
Well, I think it was just that this issue of that there was this, the adjacent wetlands reference in 404G
right.
was that parenthetical, and that he raised the thought that the words of that parenthetical, which is that's the only place in the act that adjacent wetlands appears.
Yeah, that would be the sort of hiding an elephant in a mouse hole problem that is one of the concepts behind the major questions doctrine.
And I think you're right. That is the Sackett's position, that parenthetical doesn't change the WOTUS definition, or, and that you shouldn't, Supreme Court, give such incredible far-reaching import to a one word and a parenthetical that's not explained. That might have more persuasiveness, but for the fact that it was in common use with a known definition at the time Congress used it. And they used it to make sure that the Corps of Engineers was going to keep jurisdiction over waters that had impacts on TNWs. So to me, it kind of makes sense that they knew what the Corps' definition of it was, and that's what they were using to say, yeah, Corps, you're going to keep those kinds of wetlands.
Do you think it makes any difference that the Corps kept the traditional navigable waters adjacent wetland, that only refers to that section of very important waters that the Corps is going to keep and that couldn't be covered under a state program, and that's the only place in the act that applies, or that it's mentioned?
I think the 404G use of the word is evidence that Congress understood how the word was being used and how the word now has been used for however many decades, and that it doesn't have a lot of meaning beyond that. But I think it creates problems for the Sacketts because of that. It's another point in favor of upholding the current definition of adjacency.
All right. Anne and Sarah, thank you for being here. But before I let you go, I do have some exit round questions. This is not about the ultimate ruling in Sackett 2 or the lineup of the justices. This is strictly at the sort of Supreme Court trivia level, because we're going to revisit this podcast when we receive an opinion in Sackett 2. We're going to have a wonderful reunion of the three of us. So question number 1, will we get a ruling before the end of the year? Or is this an opinion that comes out in June of 2023? Anne, your thoughts?
Not by the end of the year.
Not by the end of the year. Sarah?
Oh, hell, I'll say by the end of the year. The very end of the year.
I am going to break the tie and side with Anne. I'm feeling, though, like it's going to be more of a February-March drop than a June drop. So we'll see. That would be a long time to hold on to an opinion, to a case. And question number 2, Anne, do we get a majority opinion of at least 5 justices agreeing?
Definitely.
Sarah?
Yes.
I think I'm going to agree. I think we're going to be unanimous on this, although obviously the Supreme Court's not going to be unanimous on Sackett 2, but we will be looking forward to that opinion. And we're also going to be paying attention to EPA's Phase 2 rulemaking, which the government's advocate mentioned is at least on track for a December 2022 release. We'll see if that happens. And we might cover that proposed rulemaking in a webinar. So if you're listening to this podcast and you're interested in making sure that you learn about the other kinds of content that we push out, do go to bracewell.com, scroll to the very bottom of the webpage and click a red box that says stay connected, check all the environmental stuff, and you will be receiving our invitations to those kinds of events. So there you can sign up, and thank you for being with us. That's it for us today at the Environmental Law Monitor. Big thanks to our guests, as well as Dorn, Julia, and Emily, and the rest of our production team who helped to make our podcast possible. And of course, you, our listeners. We'll talk to you soon.